So welcome everyone to this tonight's constitutional conversation. And it's my pleasure to introduce our speaker, Gail Heriot. So we must have overlapped at University of Chicago Law School.
What year did you graduate?
So I graduated in 79.
We overlapped. I graduated in 81.
So we've known each other, maybe not real close. I can't even remember, but for a very long time. And Gail has been teaching at University of San Diego since 1989. What she's probably most famous for is that she has been a commissioner on the United States Civil Rights Commission for, I think, 12 years.
Yeah.
And since this is like the worst job in the world, she really deserves a lot of credit for putting up with this. And I bet she's written more dissents than anyone else in the history.
That is actually
right?
true, yes.
And you should read them because Gail writes, she is a real scholar. She's evidence-based. She's carefully analytical. She is objective, and in the world in the world of Washington, this is just not as common as it should be. So anyway, it's great to welcome you here tonight, Gail, and she's going to be talking with us on the subject of the 13th Amendment. So welcome.
Thank you. Okay, ladies and gentlemen, let's talk about the Constitution. The question that we have today is the 13th Amendment's ban on slavery a blank check to Congress? Which is kind of a tendentious way of wording it. So let me word it just a little bit better here. Is Congress's current view of its power under the 13th Amendment a fair reading of the Constitution? So I hope to persuade you today that Congress's current understanding is too broad, and that in addition, that understanding is inconsistent with its understanding of similarly worded sister amendments. So a little bit more specifically here, I'm trying to persuade you, I will try to persuade you, that in exercising its 13th Amendment power, Congress's aim must be, at least in substantial part, to wipe out slavery and involuntary servitude, or to prevent its return. Congress shouldn't be able to use its 13th Amendment power as just a convenient excuse to achieve other goals, however laudable those goals may be. So let's see if we can shed some light on this question. First place, first place one should look. Always look at the text first. So the 13th Amendment says, Section 1, neither slavery nor involuntary servitude except as punishment for a crime whereof the parties shall have been duly convicted shall exist within the United States or any place subject to their jurisdiction. Two little historical footnotes here. First of all, that language is taken from the Northwest Ordinance. It's modeled on that very early act of the Continental Congress organizing the area that we regard as the Midwest now, Ohio, Indiana, Illinois, where they had banned slavery right from the beginning. Second historical footnote, this may be the last time that a very important document refers to the United States in the plural. See, it says their jurisdiction. Shortly after the Civil War, it became much more fashionable to say the United States is. Before that, they used to say the United States are. We're focusing today on that second section. Congress shall have power to enforce this article by appropriate legislation. And if you look at the other Reconstruction amendments, the 14th and 15th, they have very, very similar language. This is the 14th Amendment. I just gave you Section 5 because the rest of it's too long. But it says, and you can see it's very similar, the Congress shall have power to enforce by appropriate legislation the provisions of this article. There are only three differences. This one says the Congress instead of Congress style. This one says the provisions of this article instead of just this article, because the 14th Amendment has several parts, whereas the 13th only has the 1 and 2. And they put by appropriate legislation in the middle of this one instead of the end, style. Basically, it looks like the same thing. 15th Amendment, again, very, very similar. This one's only difference is that uses that word "the" in front of Congress. And there are other post-Reconstruction amendments that use this language. 19th has the same language as the 13th. The other three I've listed there put that "the" in front of Congress. But otherwise, they're all basically the same. And why does that matter? It matters because we want to be able to interpret them in a way that is consistent across various amendments. Okay, 13th Amendment. This has happened to me several times now. Someone will ask me, "What you working on now, Gail?" And I will respond, "I've been, studying the 13th Amendment, and in particular the meaning of Section 2 about congressional authority." And they'll say, "Wait, what are you doing that? Are you becoming a legal historian or something? Slavery is dead and gone, given that it's very unlikely to return. Why are you spending your time studying Section 2? It's very unlikely Congress is going to be able to invoke this anytime soon." And what I would like to say is that these non-lawyers that keep telling me this, they're closer to being right than Congress is. That 13th Amendment is about slavery and involuntary servitude. And that's unlikely to be coming back anytime soon. Nevertheless, Congress's view of its own power, and when I say Congress's view, I don't necessarily mean every member of Congress. I don't necessarily even mean a majority of the members of Congress. I suspect it's actually a very small group that gives much thought to Section 2. But nevertheless, of those that do pay attention to it, who have had an effect on the kind of legislation that Congress actually is able to pass, they've been able to prevail in their notion that Congress has the power to ban whatever it considers, and they say they're entitled to discretion on this, whatever it considers to be a relic or vestige of slavery, untethered to the goal of getting rid of slavery and preventing slavery's return. Where did it pick up that view? Well, they got it from a case called Jones versus Alfred Mayer Company from 1968. I will talk about a little bit about that case in a minute. But what I'd like to say now is that's a common interpretation of the Jones decision, although I think it's arguably a misinterpretation. We'll get to that later. When I said that this view has led to some legislation, what legislation? Well, most importantly, the Matthew Shepard and James Byrd Jr. Hate Crimes Prevention Act of 2009. It, in part, not in whole, but in part, purports to be based on the 13th Amendment. Let me show you what I mean by that. There are actually two prohibitions in the Matthew Shepard, James Byrd Jr. Hate Crimes Act. And one of them is based on the 13th Amendment, and the other one is based on Congress's commerce power. And remember that, of course, for Congress to pass legislation, they have to be able to hang their hat on some provision of the Constitution to say, we derive our power from this provision for this particular legislation. And basically what the Hate Crimes Act does is it divides violent crimes into two parts here. Violent crimes that occur because of somebody's race, color, religion, or national origin. That is prohibited even if there's no interstate commerce nexus. And then there's another section, very similar, except the prosecution has to prove some interstate commerce nexus in order to convict. And that one covers violent crimes that occur because of somebody's religion, national origin, gender, sexual orientation, gender identity, or disability. So note that religion and national origin are in both categories. But race and color is only in the 13th Amendment side. They did not put it under the commerce power. They just put it under 13th Amendment. So if it turns out that this 13th Amendment provision goes beyond Congress's power, presumably the court could say, look, that part just drops out. That's unconstitutional. And we would be left with a Hate Crimes Act that does not cover race and color. Here's the problem. Congress didn't even claim to be motivated by a desire to end slavery or prevent its return. The Act recites that in order to eliminate the badges, incidents, and relics of slavery, that they have the power to prohibit hate crimes. So Congress is essentially saying that it has the power to uproot the badges, incidents, and relics of slavery, quite apart from whether or not their ultimate aim is to ban slavery or to prevent slavery from returning. So I want you to think for a minute about what that might mean for all these other amendments that have similar language. If the 13th Amendment allows Congress the ability to attempt to uproot the relics and vestiges of a history of slavery without any pretense as to whether or not that has anything to do with actually banning slavery and keeping it away, would it have a similar sort of power when it comes to the relics and vestiges, say, of not having women vote in elections or not having 18-year-olds vote in elections? I mean, that's an interesting way of approaching this. For example, I am told, at least, that women tend to vote more for more social spending than men do. So could Congress say, well, in order to uproot the relics of the failure to allow women to vote in the past, we can order states to increase their social spending because we believe, and we require deference on this, we believe that there will be more spending on these things if women had been able to vote over the last, 2 centuries. Or that 18-year-olds, well, if Congress decides that 18-year-olds, had they been able to vote much earlier in history, they would have exercised that power to make sure that state universities have free tuition. Can Congress order states to do that because they believe that this is a relic of 18-year-olds being denied the vote? I don't think so. But let me take a look at the history of the 13th Amendment specifically here. When the 13th Amendment was being debated in Congress, a number of members of Congress asked, how is Section 2 going to be interpreted? And the leaders in the effort to pass the 13th Amendment answered that it will be should be interpreted the same way we interpret the necessary and proper clause. So that leads us directly to that grand old case of McCulloch versus Maryland. I mean, this is one that even many non-lawyers know about. I remember my history teacher in 11th grade made sure that we studied McCulloch versus Maryland. And in that case, Chief Justice John Marshall, of course, talked about how to interpret the necessary and proper clause. And we remember that case mainly for the notion of, he allows Congress a lot of discretion. But look at what he says here. He says, let the end be legitimate. Let it be within the scope of the Constitution. And all means are appropriate, which are plainly adapted to that end, which are not prohibited, but consist with the letter and spirit of the Constitution. All of those will be constitutional. But he's not saying, hey, we let Congress do whatever they think is a good thing. He's saying, once the end is determined to be legitimate, once we see that that's within the scope of the Constitution, we're going to allow Congress a great deal of discretion on the means to achieve that end. Well, what is the end in the 13th Amendment? It bans slavery and involuntary servitude. It is not one of the more opaque parts of the Constitution. So this issue came up almost immediately after the ratification of the 13th Amendment. In 1866, just months after the ratification of the 13th Amendment, Congress passed something called the Civil Rights Act of 1866. And here's a quote from it. Citizens of every race and color, without regard to any previous condition of slavery or involuntary servitude, shall have the same right to make and enforce contracts, to sue, be parties, to give evidence, to inherit, purchase, lease, sell, hold, and convey real and personal property, and to full and equal benefit of all laws and proceedings for the security of person and property as is enjoyed by white citizens. Okay, what are they talking about here? First of all, they call it the Civil Rights Act. And when we say that word civil rights, I mean, actually, there's no agreement today on what is meant by the term civil rights, but one thing that comes up, and when I use the term, I usually first think about laws against discrimination, equal protection. The government can't discriminate on the basis of race. And, for example, the Civil Rights Act of 1964 also covers private discrimination. It includes employment discrimination. But when that term was used in the early 19th century to the mid-19th century, they meant something a little bit different. They used that term civil rights to mean basically the right to participate in civil society. And they would have contrasted it at that point with the term political rights, the rights to vote. So civil rights are the rights to participate in civil society. And what do they mean by that? Well, they mean just what was listed in the 1866 Act. They meant things like the right to own property, and in that respect, they mean like the legal capacity to own property, that the government will have to recognize that you were the owner of that property. The right to engage in a contract. Again, this is a right that one has against the government, meaning that you have to be allowed to sue in a court of law if the person you're contracting with has breached the contract. You've got to be able to sue. And also, you've got to be able to be sued. To be sued, yeah. I bet some of you are thinking, the right to be sued? Why would I want that? Much rather have the privilege not to be sued, right? Think again. Think again. If you cannot be sued, only your mom and dad will lend you money. No bank is going to want to do that because how are they going to get it back if you don't pay them? So the right to be sued basically makes it possible for people to borrow money to get credit, which means they can buy a home, they can buy a farm, they can have a business. For those things, you're usually going to need credit, especially if you are a recently freed slave. Credit matters a lot. And so they're talking about things like that in the Act, the right to sue and be sued, to convey property, to sell the property, and have that be recognized by the government. How do you define those rights in great detail? You know, from state to state, they're going to vary a little bit. You know, different states may say, well, you got to be 17 to enter into a contract, or you have to be 18 or 19, or they may have slightly different definitions of what constitutes mental incapacity, such that that right would not be yours. In some states, they may not allow certain foreign citizens from owning real estate, for example. So they varied from state to state. So it was much easier to do what they did here and sort of, describe the rights, but not in great detail, and just say, we want to make sure that everybody has the same rights that white citizens have. And they don't define it completely. They just say, you've got to have equality of this kind of right. So the fight gets started once this thing gets passed to Congress. President Andrew Johnson vetoed the 1866 Act because he thought it went beyond Congress's Section 2 power. Congress disagreed, and they ended up overriding that veto. But that disagreement, that's what was considered a close case back in 1866. So let's talk about what the arguments were here. President Andrew Johnson said, look, Congress has the authority to end slavery under the 13th Amendment. And that means giving slaves their liberty. But the inability to own property, to enter into contracts, that's not slavery. It wasn't more than 2 decades ago that married women did not have these rights. And that it was true even in 1866 that lots of people, children, anybody under the age of 21 in most jurisdictions, insane persons, in some cases foreigners didn't have those rights. And so Andrew Johnson was saying nobody called these people slaves, but Congress had a more nuanced and broader view, and it was the prevailing view, and I think it was the right view as well. Congress says, look, slavery is not a physical thing, it's not an object, it's a legal institution, and it's made up of a large number of legal rights and legal disabilities. Some of those legal incidents are unique to slavery, and you could say that the fact that the slave owner is privileged to use violence against the slave if the slave does not obey the slave owner, that's a legal incident of the institution of slavery, and that's unique to slavery. On the other hand, the fact that slaves did not have the right to marry, slaves did not have the right to own property, slaves did not have the right to testify in court against a white person, that all of these things are legal incidents of this greater legal institution of slavery. And Congress has to have the power to pass laws like the Civil Rights Act of 1866 to effectively dismantle slavery and prevent its return. And they're saying, look, the inability to own property, what's going to happen if you can't buy your own farm? You're going to have to be an employee or a sharecropper on somebody else's farm. And if that's the case, it's going to be very difficult to get out of that situation, and it's going to evolve into an institution that is pretty much the same as slavery. So they viewed the inability to own property as part of what was propping up slavery. And remember, never lose sight of the fact, there was indeed a justifiable fear that slavery in 1866 would return either in a disguised form or a not so disguised form. It was not absolutely clear that this story was going to turn out well. And in fact, there's a whole line of early 20th century cases, the peonage cases that came before the Supreme Court as well as before courts of appeal, arguing that certain kinds of relationships in the Deep South mainly basically had evolved into re-enslavement. And that they had to be broken up, and they were. There were quite a few of these cases. My point here is that in 1866, they really were worried. They were looking at the Mississippi Black Codes. They were saying, look, they're trying to reimpose slavery under another guise. So that was the first thing on their mind, and probably the second, third, fourth, fifth, and sixth thing on their mind. So they really were using that power in order to avoid the return of slavery. And it's important that nobody was arguing at the time that the 13th Amendment would allow Congress to legislate away the consequences or relics of slavery just for the sake of doing so. That's not to say they couldn't do so for the sake of preventing slavery's return. They very much could do that, but they couldn't just do it for its own sake, or at least nobody was arguing that. A little while later, Congress passes a law that outlaws discrimination or segregation on common carriers and a few other things. And so the issue gets before the Supreme Court in a case that gets combined into the name of the civil rights cases. And the court held that Congress can, in the exercise of its 13th Amendment power, outlaw badges and incidents of slavery. And when I wrote this for the slide, I used the word held, but that's actually not true that they held it. Rather, they said it. They said it, but it didn't actually drive the decision in that case, because ultimately they held that what Congress had done in outlawing discrimination or segregation on common carriers, that was neither a badge nor an incident of slavery, and therefore the law was held not to be a proper exercise of the 13th Amendment. So that language, though, comes up, badge, incident. It was mainly used during the debates over the 1866 Act in Congress. They kept saying, these are badges and incidents of slavery. And the word incident had been used to talk about, the legal privileges and constraints, legal constraints imposed on slaves, legal privileges imposed or allowed to slave owners. So the legal privilege of slave owners to punish a slave who's unwilling to work, legal prohibition on a slave acquiring his own property, things of that sort. Badge, that term before the Civil War was used in all kinds of ways. But by the time you get after the Civil War, nobody mentions badges by themselves. Badges and incidents had basically become one word. Badges and incidents, badges and incidents. And they tended to mean what we would call legal incidents today. I have sometimes wished that the Supreme Court had never used that term, badges and incidents, because I think it may obscure more than it really, really helps. It might have been easier to simply say Congress has prophylactic power under the 13th Amendment, meaning that they can outlaw things that are not strictly speaking slavery, if the idea is that this will help them in actually getting rid of slavery and preventing its return. The hypothetical I've sometimes used is this. If I were to invent a drug that makes people servile, when you take the drug, you want to be a slave, and you go around and you say, please let me be your slave. And let's say, just to keep the commerce power out of it, I never sell it. I just give it away, and nobody's ever sold it. So let's just try to put commerce aside here and try to bring it under the 13th Amendment. I have no doubt whatsoever that Congress can criminalize my going out and giving away this drug, because it leads to slavery. People keep asking to be slaves, and of course somebody out there is going to say, sure, you can be my slave. And so sure, Congress can do it. They have that power, even though the drug itself is obviously not slavery. It's just something that brings on slavery. Okay, but in discussing the 1866 Act, it's not surprising they wanted to use that term, badges and incidents, and they don't talk about it in terms of broad prophylactic power, because what they were actually doing was outlawing certain legal incidents that were connected with slavery, and they did it because they wanted to prevent slavery's return. My point here is simply when the Supreme Court used that term and when they decided the civil rights cases, they were not, their aim was not to be inconsistent with McCulloch versus Maryland. Presumably, even though they're saying, yes, Congress can outlaw badges and incidents, they're still imagining, since it's not that long after the Civil War, that this is for the purpose of getting rid of slavery and keeping it away. Then we come to the swinging 60s. And here I'm talking about the 1960s, not the 1860s. And there was a trio of cases that dealt with these Section 2 of the 13th Amendment, Section 5 of the 14th Amendment, and Section 2 of the 15th Amendment. The case I care about the most here, and I want to describe to you, is Jones versus Alfred Mayer Company. All three of them used language that was very deferential to Congress, and saying, Congress has we should be deferential in the means that Congress uses to achieve its ends. They didn't talk much about the ends, but the Jones case is a fascinating one because it was a ghastly case because it was just pure raw racial discrimination. The developer did not sell to African Americans. This is a real estate developer. And at the time, Missouri had no law against race discrimination in the sale of real estate. But when I say it came at a ghastly time, the case was argued before the Supreme Court 2 days before the Reverend Martin Luther King was assassinated. And so suddenly, and it wasn't just in Washington, of course, it was also in many other cities, but there were riots in Washington, and they were not small riots, 6,000 arrests, 1,000 fires, 12 deaths. government buildings were evacuated. I tried to find evidence that the Supreme Court was evacuated, and I haven't been able to find that, but I have found that buildings that are like within a block, government buildings were evacuated, so I suspect it was true of the Supreme Court. And, you know, it was a difficult time. Here's the weird part. Remember the 1866 Act that I showed you a minute ago? The argument in the Jones case that was being made by Mr. and Mrs. Jones was that federal law already prohibited race discrimination by the real estate developer, by private parties, in the sale of real estate. And the act that they pointed to was essentially the same as the act we talked about a minute ago. The wording is a little bit different because it was repromulgated a little bit later, but it's pretty much the same. And the argument was that this is not simply capacity to own property. You know, that is capacity in the sense that the government has to recognize that you own the property. They argued here that it actually governs not just the government, but also private parties. And, well, you know, maybe we should talk more about this in the question and answer period, because I could go on this forever. That's a misinterpretation of this statute. This statute does not ban private parties from engaging in race discrimination. Maybe it would have been better if it had done so, but just historically, that's not what they were thinking of. They were thinking of the government recognizing that you own the property, treating you as the owner, the legal capacity to own property. And, you know, among the ways you can tell that, let's see. Well, first of all, as is enjoyed by white citizens. White citizens in 1866 did not have the right not to be discriminated against on the basis of race. Probably wouldn't have happened very often, but they didn't have that right. Second, the 13th Amendment controversy between Johnson and Congress gave Congress the willies. They started worrying, well, maybe the court's going to agree. And so they repromulgated this act under the 14th Amendment, saying, now we've nailed it down. Now it's constitutional. Well, the 14th Amendment doesn't cover private actions. It only covers government action. And so that would not have been a good argument for them. At any rate, I'll give you more arguments if you want them. But at this point, just trust me, that's not what this act was supposed to be about. But you can understand why the Supreme Court, it was a tough time. You know, it was 1968. This was a difficult thing for them. And so I've written wrong because it is wrong. I mean, just as a matter of legal history, that is not what the act said, and it's not what the act meant. But that's what they did. Now, the second part here, they also decided that they decide this bans private discrimination, and then they turn around and say, and that's appropriate under the 13th Amendment. And that's not necessarily as wrong. I mean, that's not necessarily wrong. If you assume that their interpretation of the act is correct, and that that's what Congress did back in 1866 and then repromulgated again a couple of years later, if you assume that's what they actually did, then okay, why would Congress have banned private discrimination in the 1860s, assuming that they did? They might well have thought that this is something they need to do in order to prevent the return of slavery, because at that point they really were concerned with that. They really were, desperate on that basis. This was not a small thing for them. The thing that the Jones case does is it keeps throwing around this language about relics and vestiges. That's not a great idea, but they did it. And since then, some people have interpreted the Jones case to say, first of all, that Congress has to be accorded a lot of discretion in determining what is a badge or an incident of slavery. And that's right. They should be. If we're basically talking about means to achieve an end, we want a lot of discretion for Congress. We want that. But if we're going to say that Jones said that Congress has the power to ban badges, incidents, relics, and vestiges of slavery, even though it's unconnected to any ultimate aim of exterminating slavery or preventing its return, that's going a lot further. Okay. I told you that in the 1960s, all the emphasis was on discretion for Congress, and they weren't really thinking about the question of whether or not the aim has to be one that's clearly allowed, or even not so clearly allowed under the actual Constitution. By 1997, we started getting interpretations of Section 5 of the 14th Amendment, and a little more than a decade later, Section 2 of the 15th Amendment, that goes back to this notion of, you've got to have some connection to something that is substantively prohibited by the 14th Amendment. And Congress, Supreme Court ends up saying in a case called City of Bernie versus Flores that a statute passed pursuant to Section 5 has got to be congruent and proportional to some real threat of 14th Amendment violations. It can't be for some other purpose. I mean, what was at issue at that case was a statute that required that states and local governments allow religious institutions, in this particular case, to use land in ways that are helpful to them. And the problem was it wasn't clear that any of these states were actually violating the 14th Amendment, and therefore, since the Section 5 is supposed to be there to help Congress remedy and prevent violations of the 14th Amendment, the court ends up saying, hey, it's not congruent and proportional to any real threat of 14th Amendment violations. 15th Amendment, same thing. In 2013, the pre-clearance provisions of the Voting Rights Act of 1965 were being considered. The court had already upheld these provisions in the 1960s because pre-clearance provisions basically required states that had been thought to discriminate against African Americans as voters. They have to go to the Department of Justice or to the courts whenever they make any kind of change whatsoever in their voting requirements. Any change, even like moving the precinct from the Methodist Church to the Presbyterian Church across the street because they had a flood at the Methodist Church and they had to move it. Anything has to be approved either by the federal government, either by the Department of Justice or by a court. It's very, very onerous, and the court upheld that back in the 1960s because it was quite clear that you really needed tough action if you wanted to break the back of Jim Crow when it came to voting rights in the South at that point. So they upheld it. But when it was repromulgated, that was a temporary part of the statute. When it was repromulgated decades later, and there was no evidence of the same kind of discrimination, they end up saying, you've got this statute passed pursuant to Section 2 of the 15th Amendment, but it has to be a rational response to a real threat of 15th Amendment violations. And when we say rational, it means that, the difficulties of doing this, that has to be worth it to impose this much extra work on the part of these jurisdictions. You got to have more evidence that there are real violations going on. They've got to be the evidence has to be up to date. Okay. So I have argued to you that since Congress hasn't even claimed, and realistically wouldn't claim, that the Hate Crimes Act is necessary to ban slavery and to prevent its return. I've argued that it's beyond the power of the 13th Amendment, using McCulloch versus Maryland. Has the Supreme Court signaled the same kind of willingness to take another look at the 13th Amendment as they have now with the 14th and 15th Amendments? And the answer to that is they've had a couple of opportunities now, but every time it's been cert denied. That doesn't mean that they won't grant cert later. Remember, the fact that the Supreme Court declines to take a case doesn't mean that there's now precedent in favor of the opposite view. They could still take it. And what's interesting is that a couple of courts of appeal have tried to signal to the Supreme Court, we'd like some more guidance here. We'd like you to take on this issue. The Fifth Circuit basically said, we would like more guidance in this area, recognizing that the arguments that this is beyond the scope of the Congress's 13th Amendment power. They recognize that that has some weight, but they felt that they were constrained to go with the interpretation of the Jones case that Congress was going with. The 10th Circuit, similar, said, the federalism arguments here are very weighty, but we feel constrained by Jones. So they don't buy my argument that Jones can be interpreted in a way that makes it not a problem, but they recognize that the issue is serious. What would happen if the Supreme Court were to declare that this portion of the Shepard-Byrd hate crimes law, based on the 13th Amendment, is unconstitutional because it's beyond the scope of Congress's Section 2 power under the 13th Amendment? My guess is there'd be a lot of political pressure to amend the act to bring race and color under the commerce power section. It's a bit more limited because it requires that prosecutors prove in each case a sufficient commerce nexus. But I suspect there would be such pressure, and I suspect that a lot of members of Congress would be willing to do exactly that. Is it worth it? To me, it's worth it because it's worth it to have integrity in the Constitution. It's worth it to make sure the 13th Amendment is being interpreted properly. But there are also two issues that are not constitutional issues that Congress may, and some members of Congress would like to address with the Shepard-Byrd Act. One thing a lot of people don't realize, it's called the Matthew Shepard and James Byrd Jr. Hate Crimes Prevention Act of 2009, but it doesn't actually require hatred. The word hate only appears, in the heading. There's nothing in the actual prohibition about hatred, group hatred. So what it instead says, any violent crime that occurs because of somebody's race, sex, blah, 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 blah. So, think about it. Here's an issue that's kind of interesting. Rapists are seldom indifferent to the sex of the person they are attacking. Some people argue that all rape should be viewed as a hate crime. Other people are not so sure on that. And that issue is up for grabs here. I think pickpockets, guess what? We've written a statute that literally makes a pickpocket who targets women because the pickpocket thinks that he can outrun them, or targets the disabled. That literally fits the definition of a federal hate crime. I would like to think that prosecutors won't do anything quite that silly and call that a hate crime, but don't bet the ranch on it. Double jeopardy. Why do we need a federal hate crimes act? Almost all states already have a hate crimes act, and even those that don't always outlaw the violent crimes that the federal act outlaw. A lot of the argument behind closed doors for the Federal Hate Crimes Act, and sometimes not behind closed doors, was we want to be able to have a federal act in case somebody is acquitted of a crime in state court, and we want to re-prosecute him. You read of it in the newspaper all the time, right? I mean, right after George Zimmerman was acquitted of the murder of Trayvon Martin, there was a lot of pressure. Let's try him in federal court now. Whatever happened to the double jeopardy clause, right? Wrong. Double jeopardy clause does not apply in a case where you've got two different sovereigns. So if California prosecutes someone under their act, the federal government is not prevented from prosecuting that person as well, even if the person is acquitted in California court, and even if there's no way to acquit that person from the state crime unless they're also innocent of the federal crime. You're not protected from double double prosecutions in that situation. And, in a day when there weren't that many federal crimes, used to be that federal crimes are like, something that you do in a post office, or you attack a federal officer, or something that occurs, on federal property. But these days, lots of crimes have nothing to do with federal property and don't have any special federal side to them, except for these very attenuated kinds of things where they try to, for example, bring it under the 13th Amendment. To me, that's a particular problem in the hate crimes area because these cases tend to be so emotionally charged. There are Department of Justice rules about when they will re-prosecute, but they're pretty easy to stretch when you want to. So should the act be amended just to say no retrying after an actual acquittal? Maybe somebody would want to do that. But those are things that have to be considered. That, I think, is really all I need to say right now. And I've gone past the period I was supposed to, so why don't we go to questions?
I have a microphone here. If anybody has a question, I can pass it to you.
Have there been any significant judicial or other developments regarding the issues that you've described today since the Supreme Court denied certiorari in the Metcalfe versus United States of America case?
No, not since the Metcalfe case. Not that I know of, at least. That was their last cert denied. There have been no further decisions that I know of, although I can't say that I know what's going on in every single trial court.
So this is a slightly dweeby question, I suppose, but
Slightly what?
dweeby. I'm maybe in the right setting for it. So I was thinking, so the premise of your presentation is essentially about the remedial power, right? So Section 2 of the 13th Amendment, and you compared it, in pari materia to these other subsequent amendments. I'm sort of wondering if you take a step back from that, like assume, the 13th Amendment is ratified in 1865, and then Congress never passes a single statute to enforce it. How much work does the 13th Amendment do on its own? And the reason I'm kind of interested in this question is, right, I believe it is more or less considered to be unique among constitutional provisions in that it directly regulates not just governments but private individuals. In other words, so Congress...
It's also considered to be self-executing.
Self-executing, right? So no enabling statute. Congress maybe takes the position 1866 Civil Rights Act is redundant.
So Congress...
So in other words, without reaching some of the questions you're addressing, is there room for essentially, I guess, sort of like a common law of the 13th Amendment or individual litigants sort of establishing rights under that?
Yeah, and I mean, it's interesting in that, like, Section 2 gives power to Congress.
Right.
That is not exclusive, but what does it give to the courts? And I don't think there's any reason to believe that the court should have the same discretion that Congress has. I mean, if it did, why not say Congress and the courts? Why would they have the same level of discretion? What can the court do? When we say it's self-executing, then presumably what? How do we make it self-executing? Other than, if a slave decides, this says I'm not a slave anymore,
Right.
bye. Okay, and let's...
Or for example, the scenario, Congress won't act, perhaps because, between the period of 1876 and the mid-1960s, they're not so inclined. I'm going to sue a private, person or a governmental institution on my own. Court give me...
Who are you? Are you otherwise
Sure.
a slave?
Yeah.
Okay. And so the first thing the court says is that you actually you can't sue because you don't have, you don't have the capacity to sue.
Right.
Because there's been no 1866 Act. So at that point,
slavery means more than just slavery.
yeah, yeah. But if once we start from the notion that this is self-executing, then I think we do have to say the court can say no. Even though the capacity to sue is not necessarily something that is not unique to slavery. Nevertheless, if we're going to have this thing actually be self-executing, you at least got to be able to get your foot in the door, right? That doesn't mean necessarily that they have the same level of discretion that Congress has, but they have the, if we call it self-executing, we don't really mean it's self-executing. We mean that courts can execute it in some way. I mean, it's self-executing in the sense that if you're the person who had up to that point been regarded as a slave and you walk off the plantation, then sure, it's self-executing in that sense. But when you get arrested, actually you don't need to do this because, okay, you get arrested. They try to convict you of a crime, then you've got the fact the 13th Amendment is on your side, and so there's no special side of that. But that's not what they're going to do. They're going to return you to the slave owner, and you're going to walk off again, and ultimately somebody's going to have to bring an action in court to get this thing moving. And so, yeah, I think at that point, sure, there's certainly remedial power there. It's just a question of whether or not it's coextensive with Section 2, and I don't know why it would be. You'd have to give me a hypothetical about that, the outer limits of that. Would they be able to declare my drug that causes people to be servile? Would they be able to declare that illegal? I wouldn't think so.
I guess look at it this way. So if Section 2 gives Congress the power to sort of rationally...
Lots of prophylactic power.
Right. Define these limits, but Congress chooses not to do so, right? Nowhere in the 13th Amendment does it say, this shall be the exclusive means of enforcement. Why can't the federal courts create like a very detailed common law for the 13th Amendment? And then if Congress doesn't like it, they can say, okay, well, this is what we think it means, and then you can have that.
Well, this sort of was to prevent it. There's nothing to prevent the courts from using the same kinds of remedial power they do in other contexts, and there's nothing that would prevent Congress from saying no. We're not going to allow you to do that. But when I think of Congress's power, I think of much broader than is traditional in the common law. And so I'm not convinced that the courts would have the same level of discretion, but we'd really have to explore what the outer limits of that are for both Congress. I can't spin it out right now, but I can certainly agree with you that since we view the 13th Amendment as self-executing, that's got to give the courts some remedial powers. It's a question of what kind. I wouldn't think it gives them extraordinary remedial power, whatever that might mean in context.
So let me play devil's advocate here for a second and talk about the hate crimes bill and what a member of Congress might say in response to your analysis. So when slavery was formally ended at the end of the Civil War, there were private violence was used on a quite widespread basis in order to terrorize the freedmen out of exercising their rights. The Ku Klux Klan was just one of a number of organizations that did this, and so one of the pieces of legislation that Congress passed at the time in 1871 was the Ku Klux Klan Act to prevent this private violence. And so now, why can't Congress in what was it, 2008? When did they pass the Shepard-Byrd Act? 2009. So why can't Congress in 2009 say that racially motivated violence is similarly designed to terrorize black people into not exercising the civil rights that they're now entitled to exercise as free people? and in much the way it may not be quite as organized or as widespread as the Ku Klux Klan in 1871, but it's the same kind of thing. And so the Shepard-Byrd Act is just as constitutional today as the Ku Klux Klan Act was in 1871. I'm just curious what your response would be to that.
13th Amendment isn't about race, it's about slavery and involuntary servitude. If you could show that hate crimes were being used to scare people into not exercising their rights to vote under the 15th Amendment on the basis of race, that strikes me as a more plausible argument, if that could be shown. Note that it wasn't shown, and that was not the argument. Their argument is that we can do this because it is itself a relic, not because it has any connection. And they deliberately chose not to. It seems to me you've also got a 14th Amendment argument if they only had it, and they didn't. And that is, if you could show that state governments were not prosecuting hate crimes, they were not prosecuting crimes that were levied against a particular race, and you could show that the state government is somehow failing in its duty of equal protection under the laws, could they say, okay, we are going to have this Hate Crimes Act to make it a federal crime because we believe the state is falling down on the job. But they fell all over themselves to say that wasn't the case. And so that kind of louses up the 14th Amendment when all the members of Congress are saying, we believe the state governments are doing a great job, but we're just trying to help.
I think we have time for one more.
Well, not seeing one, would everyone just join with me in thanking Gail? So let me encourage everyone to come next Monday. It's very soon at 5 o'clock. Watch your emails to see, but I believe it's 5 o'clock. Professor Chaim Simon of Villanova University is going to be talking about Jewish law. Now, you may ask yourself, what does this have to do with the United States Constitution? And the answer to that is actually quite a lot. That many of the principles of Jewish law were known extremely well to our framers, and there's actually a great book on this by the historian Eric Nelson called The Hebrew Republic. And so some of these themes are going to be in Professor Simon's talk next Monday, so encourage everyone to come back and learn from him. And so with that, thank you again, Gail.